Megan Newport appear for the state. Joining us at council table is Detective Joanne Donner.
Good morning. Maxwell Anderson appears in person with Attorney Anthony Cotton and Jason Finley.
Good morning, everybody. So welcome back. I hope you had a lovely evening. We are ready to now begin. At this point, I'm going to read to you the instructions, and then we're going to proceed into opening statements. Following that, we'll go right into our first witness. So, before the trial begins, there are certain instructions you should have to better understand your functions as jurors and how you should conduct yourselves during a trial. Your duty is to decide this case based only on the evidence presented at trial and the law that I give to you. Anything you see or hear outside this courtroom is not evidence. All people deserve fair treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. People make assumptions and form opinions from their own personal backgrounds and experiences, and generally we're aware of these things. But you should consider the possibility that you have biases of which you may not even be aware, which can affect how you evaluate information. Preferences or biases have no place in a courtroom. Our goal is to treat all parties equally and to arrive at a just and proper verdict based on the evidence. Do not begin your deliberations and discussions of this case until all of the evidence is presented and I've instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It extends to all forms of electronic communications. Do not use any electronic devices such as mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. We will stop or recess from time to time during the course of this trial, and you may be excused from the courtroom when it is necessary for me to hear legal arguments from the lawyers. If you come into contact with the parties, lawyers, or witnesses, do not speak with them. For their part, they will not contact or speak with you. Do not listen to any conversations about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by electronic means. Do not read any newspaper reports or listen to any news reports on the radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness on this case. Any information you obtain outside this courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you're serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so, despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, selected for this duty. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. The first count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, in Milwaukee County, Wisconsin, did cause the death of Sade Robinson, another human being, with the intent to kill that person contrary to Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charge beyond a reasonable doubt. Now, first-degree intentional homicide is defined in 940.01 of our criminal statutes and is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. One, that the defendant caused the death of Sade Robinson. Cause means that the defendant's act was a substantial factor in producing the death. The second element is the defendant acted with the intent to kill Sade Robinson. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill must be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something, while motive may be shown as a circumstance to aid in.
I wonder if the divesting community going to cover this story or not. I'm also wondering if the Jemimas and Sambos are going to cover this as well. I'm going to tag them all into it. We'll find out if any of them do this story. If they don't, then we know they really don't care about black women.
Intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. Now, the second count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, in Milwaukee County, Wisconsin, did dismember a corpse with the intent to conceal a crime, contrary to Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of this offense charge beyond a reasonable doubt. Section 940.11 sub 1 of our criminal code is violated by one who mutilates, disfigures, or dismembers a corpse with the intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following two elements were present. Number one, that the defendant dismembered a corpse. Number two, the defendant dismembered a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and the circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The third count of the information in this case charges
the face of a murderer, dismembered young Sade Robinson, and then distributed her body parts all over Milwaukee.
Did intentionally damage the property, other than a building, of Sade Robinson, valued at $100 or more, without that person's consent, contrary to Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Arson is defined in 943.03 of our criminal code and is committed by one who, by means of fire, intentionally damages any property of another without the person's consent if the property is not a building and has a value of more than $100. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following five elements were present. Number one, that the defendant intentionally damaged a 2020 Honda Civic by means of fire. Damage means injured, charred, defaced, and includes smoke damage. Intentionally means that the defendant must have had the mental purpose to damage the property of another by means of fire, or was aware that his conduct was practically certain to cause damage to the property. The second element is that the 2020 Honda Civic was the property of another. Property of another means property in which a person other than the defendant has a legal interest, which the defendant has no right to defeat or impair, even though the defendant may also have a legal interest in the property. The third element is that the defendant damaged the property by fire without the owner's consent or the consent of the owner's authorized agent. The fourth element is the value of the 2020 Honda Civic was $100 or more. The fifth element is that the defendant knew that the 2020 Honda Civic belonged to another person, and that the person did not consent to the damage of the property, and that the value of the property was $100 or more. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in the case bearing upon intent and knowledge. If you're satisfied beyond a reasonable doubt that all 5 elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The fourth count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, in Milwaukee County, Wisconsin, did hide a corpse with the intent to conceal a crime contrary to Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of this offense charge beyond a reasonable doubt. Section 940.11 sub 2 of our criminal code is violated by one who hides or buries a corpse with the intent to conceal a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. 1.
Thank you all for coming back to the Black Only News and Entertainment Network. Peace, take care, and be safe. I will be covering more of this heinous murder